Well, hi there and welcome to Law Call. I'm Neil Gordon. Tonight, the answers to your legal questions. Here's what's ahead on the program. In our caller segment, we'll discuss hurt on the job, workers' comp. If you're involved in a situation, we'd like to hear from you. You can call right now. The lines are open at 803-442-4551. Later in the program, we'll hear about what you should do if you fall in a business or on someone else's property. First, though, Attorney Vic Hawk is here to take a look at one of your email questions. Hello there, Vic.
Hey, Neil.
How are you?
Happy to be here.
Great to have you. We're going to kick things off with an interesting question. It comes from Mr. Smith. He wanted to know, Vic, how is it determined if a juvenile is charged as an adult in a crime? And likewise, how come the reverse happens? Adults are sometimes allowed juvenile status.
Mr. Smith, the reason is that our legislature has passed a law which says certain serious criminal offenses, murder, rape, arson, child molestation, are offenses that are so egregious to the public that the prosecutor has the authority to transfer the offenses from juvenile court to try this young person as an adult. The judge has some discretion to keep it there, but as a general rule, the judges do not do so. Now, in a rare occasion, I can think of where an adult may be charged as a juvenile. Say, for example, if a juvenile committed an offense that was not very serious and they were now 18 years old or 19 years old, but it occurred when they were 16 years old, then in that event, that adult would be treated as a juvenile and prosecuted in juvenile court. I've also seen other cases where adults were not allowed to be treated as juveniles, say, for example, when they're charged with serious offenses, and they would not be amenable to juvenile supervision or correction.
Okay, very interesting, both sides of the spectrum there. If you'd like to get involved and ask a question, a couple ways to do it. You can call in, of course, or you can go online and submit a question. A couple of ways. One would be to go to Vic's website at vichawklaw.com or here to News 12 site. The URL is wrdw.com. You can learn about upcoming programs. You can also click on the right-hand portion of the screen and fire off an email question, and we may go ahead and place it on the air coming up. We're going to take your questions live in a moment. Again, the phone number 803-442-4551. And before we go ahead and introduce our topic and our guest attorney, Vic is going to score some points with the folks at home.
That's right. You know, I went to law school in Alabama, and I was lucky enough to find an Alabama wife. And today was a big day in the Hawk family. Our youngest grandson got christened this morning. And Ellie, my oldest granddaughter, had her birthday and a big fishing tournament at our house. And more importantly, my mother-in-law, Mama Jo from Alabama, was able to come and spend the weekend with us, and my wife's good friend Stephanie. And so it was a great day for us. And I want to say hello to them and tell you how much we appreciate you coming and love you for doing it.
You did very well.
Thank you.
Smart man.
I'd make a few points.
I know you do, definitely. Well, important topic tonight. I mean, thousands and thousands of folks, of course, get hurt all the time in Georgia and South Carolina, and I think we're covered on both sides of the river tonight.
Absolutely. Tonight, I brought on someone who's a great trial lawyer, and more importantly, he's one that represents the other side of the fence from the plaintiff's bar. He's principally done workers' compensation defense work. He does some claimants' work, but he's been practicing for 28 years. He practices there in Aiken, South Carolina. He is a member of the Defense Trial Lawyers Association in South Carolina, and he's a specialist on South Carolina workers' compensation. And tonight, Clark, this is Clark McCants. And Clark, can you tell our viewers what is a repetitive motion injury and when can it be filed in South Carolina?
First, congratulations on your big day.
Thank you very much.
And thank you again for having me. I can imagine. In South Carolina, like a lot of other states, repetitive or cumulative motion type injuries are a relatively new breed of injury. Traditionally, South Carolina did not view those as accidents on the job because there was no one precipitating event, no one acute problem that arose to cause these problems. But in the mid-1990s, South Carolina, like a lot of other states, began to recognize that accidents can happen over time. And in fact, what we have today to produce cumulative or repetitive motion type injuries are many accidents over a period of time. Our state legislature has dealt heavily in this issue in the last few years, and in fact, today recognizes by state statute that a cumulative or repetitive motion type injury is compensable under our workers' compensation law, and there are some requirements. Specifically in South Carolina, at this point, you have to have a medical doctor connect the work activity to the condition that is being diagnosed as some type of injury. The most typical example that you can find would be a carpal tunnel syndrome that a lot of people are familiar
like a
with regard
production
to.
worker
Absolutely.
or someone who works on a computer throughout the day.
That's correct. And the reason we require a medical opinion to establish that causative link between the work activity and the injury is because there's so many other causes for these medical conditions. And our commission, our state statute, and our legislature has wanted a medical opinion to establish that connection.
And it's the same way in Georgia. Not much difference at all in
Sure.
that regard.
Go
ahead.
I was just going to say, let's find out how, I guess, James got hurt on the job. James, can you hear us?
I sure can.
Oh, super. We hear you were turned down on your first appeal. Is that right?
I was.
How did you get hurt on the job?
Okay, I drive. I'm in the transportation business, and so it's freight. You're always lifting, you're driving, you drive, you're lifting, you're climbing, and it's repetitive motion with your ankle. Well, right now, my ankle, I've got a, I don't want to say nerve, but it's like there's something with the nerve inside of the ankle that's not healing, and I've been on transitional duty, and I've just moved from short term and now long term, and that's through just my regular insurance from the job, and they're not going to carry me anymore. And because of, I want to know where my next step is after I've been turned down already by workman's comp. But the ankle, it seems like my next stage could be surgery, and I'm still astonished because this happened on the job. It was just repetitive motion.
Clark?
James, the first question I would fire back at you is whether or not you have an attorney representing you at this point.
James, are you still there?
Yes, I am.
Okay. I don't know if you heard, but Clark wanted to know, do you have an attorney representing you, or are you sort of thinking if one could help?
I don't have one representing me, and that's my question. Can I get help? I mean, I'm in a position to where, now I'm not drawing any income, and it's.
Well, let me offer to James, if I can. I hope you picked up kind of with my brief statement about this type of injury. It's a very complicated type analysis in South Carolina with regard to the compensability, as we call it, of this type of injury. It's one typically we find that there are attorneys representing injured workers involved. It's not the run-of-the-mill broken bone, something of that nature. It's very complex. I would urge you probably at this point to consult with legal counsel, because the way you describe the injury, that is the cumulative, the repetitive nature of your particular job, I could see how it could produce an injury.
Right. Yeah, he needs to get to a South Carolina workers' comp lawyer right away.
I know a good one, I think. Clark is here to help. Susan's calling also from South Carolina. Susan, how are you?
Hi, I'm fine.
Oh, good. Well, we hear that, thank you. You work for a nonprofit, which is a great calling indeed. What happened on the job there?
Well, I used to work for a nonprofit. I had to quit. They changed my job title. And for the love of the nonprofit, I didn't want to have them to pay out of their pocket, because that's what I worked for more than 10 years.
Did you get hurt on the job?
I don't really know where I got hurt, because I've worked a lot of heavy jobs, and I have worked for airports, pushing and pulling planes, and this, that, and the other. Anyway, but it was about 7 years ago that I had a foot that was swelling, and I thought I had broken my foot because I used to move doors with it.
Did you ever file a claim for workers' comp?
Never did, because I didn't want to take any money out of a nonprofit that I was working for. Call me stupid.
Too late, Clark?
Susan, you're not that's pretty typical for folks who work for charitable or nonprofit type organizations, and your dedication to it is to be noted. However, you do have certain rights. I would suggest to you that 7 years is a good long period of time that is passed, which I trust with no reporting to the employer or anything of that nature. So I would be concerned about the time frame involved. But what I would suggest to you is, in your area, probably consider consulting with some type of legal counsel. This, again, is a complex issue. The notice, the statute of limitations, and the time that's necessary to present these claims.
Let me ask you this, Clark. What if she developed, in other words, the onset of this injury continued over a long period of time, and then she was unable to continue employment anymore? Does the statute extend to the date that she's unable to continue employment?
That's an excellent question. It's one that's very complex because we go back to these mini accidents. When I say mini, M-I-N-I, over time.
In Georgia, there's a basis for that, but it depends on her reporting.
Sure.
She should really consult.
And it has a lot to do with what the doctor
has
has said too, and when your problems first began, and when you became aware that maybe they were connected to work.
Okay.
Well, if you've been hurt on the job or have some questions related to it, we want to hear from you. The number, 803-442-4551. You're watching News 12 Law Call.
If you've fallen or suffered any type of injury at a business or someone else's property, it's important to establish whether or not the property owner bears any responsibility for your injuries. There are several things you should do immediately to get the ball rolling. Preserve the conditions that caused the injury by taking a picture or videotape of that area. Consult your primary care physician to evaluate exactly what your injuries are. Whatever you do, act quickly. If you don't get the required notice or file a claim within the strict time limit, you'll lose your ability to recover damages. The property owner is only liable if you can prove that he created the dangerous condition, knew about it, or should have known about it, and didn't do anything to correct the problem. The burden of proof is on you. An experienced premises liability attorney will be able to tell you whether or not you have a claim. I'm Attorney Reed Sanders of the Vic Hawk Law Group. Back to you.
Thank you, Reed. We're talking workers' comp tonight with Vic Hawk on the Georgia side of the law, and also Clark McCants III, who handles Aiken cases and other cases in South Carolina. Larry joining us now from Aiken. And Larry, what is your question tonight for Mr. McCants?
Okay, my question is, I had surgery Friday, and work compensation, they better for all of that. I'm just wondering, do I have to file AFLAC with that too?
Well, first, Larry, I hope you're recuperating well from your surgery. Sorry you've been through that. I'm going to have to ask you again to state your question. It sounds like you're asking whether or not you should file on a particular insurance even though you're hurt on the job. Do you have some private health insurance with your job?
Right, AFLAC.
Okay, all right. I understand now. Typically, a private health insurer is not going to cover you under that policy if you got hurt on the job. And if what you're telling us this evening is that your injury arose out of your work, you need to make sure that you're coordinating your benefits through your employer for workers' compensation benefits. And again, AFLAC or the private health insurer that's involved will recognize if you're saying that you got hurt on the job, that is probably not covered under that private health insurance.
I always thought that AFLAC kind of covered you just for situations like that. But that's just good marketing, right?
They got some fine print in there, Neil.
There's a provision that says that if it's work-related, they're not responsible. And also, if it's covered under workers' comp, it's paid under a particular schedule.
Okay.
So that if an employer accepts workers' comp payments or the medical provider accepts workers' comp payments, that schedule determines how much they receive, and so you don't really have any need to file on any private insurance.
Can't really
AFLAC,
double dip, if you will, kind of thing.
No double dip.
Makes sense now, I gotcha. Well, Gary joins us from South Carolina. Gary, first of all, so sorry to hear. What happened at an area restaurant to you?
Me and my wife went into a restaurant, a nice little restaurant that everybody likes around town. But when the waitress comes out and hands her, they got a meal that's in a hot plate, a real hot plate. He had his gloves on, and he handed it. He didn't set it down on the table. He handed it to my wife.
Oh.
And when he did, it burned all 10 fingers.
Oh.
She had them. We got her sticking her fingers down in the ice. But the problem is, we went to the hospital, went over to the burn center. Also, she had to go back and forth over her second-degree burns on about like 6 fingers. Okay, I called him up, right? I called him up. I asked him, I said, what you want to do about it? He tells me he ain't got no insurance. What should I do?
Wow, obviously it's not a workers' comp,
Yeah.
but this certainly, is it going to have to be sort of a civil situation, you think?
Gary, I'm understanding that you and your wife were customers of the restaurant, again, and experienced this unfortunate incident. We certainly hope your wife is recovering well in that regard. Whether or not the restaurant has insurance doesn't determine whether or not you can pursue a claim against that company or that restaurant. What I would encourage you to do is, again, consult with an attorney in your particular area. That attorney can do some research to determine whether or not the restaurant has financial means, assets, whatnot, to satisfy your claim. And of course, they've also got to investigate and determine the degree to which the waitress or waiter involved was at fault. So just because they're saying they don't have insurance does not mean you cannot pursue your claim.
And Vic, sometimes they say they don't have insurance to the customer, but that isn't always the case, right?
That's right. Sometimes you have these small proprietors that have insurance, just don't want to file on it, and they'll tell you they want to just pay your medical bills. So you should pursue it, and if the medical bills are not that high, there's a good chance that you can get that proprietor to pay for that.
Well, we're just kind of getting started. We'd like to take some more of your calls. The number again, 803-442-4551, Workers' Comp on News 12 Law Call. Well, thanks so much to Clark McCants III coming on tonight from the Nance McCants and Massey firm in Aiken. The number to call in the morning, 803-649-6200, online at nancefirm.com. You can reach the Vic Hawk Law Group at 706-722-3500 or online at vichawklaw.com. We're going to take Connie and Gary's telephone number in just a moment, continuing our talk about workers' comp. But we're going to begin a new segment tonight we call the Legal Alert, keeping you abreast of topical issues like Tylenol.
Absolutely. What we're going to start doing at the end of the show is letting y'all know about new developments that are affecting the public in general. And I just came back from the Georgia Trial Lawyers Association. Tylenol has now been certified as a mass tort piece of litigation that's going to come out of Pennsylvania. And what's occurring is 56,000 people are going to the emergency room every year with liver failure. 28,000 are hospitalized, and 400 to 500 per year are dying. Half of those deaths are caused by Tylenol. It's arising from the margin of error in the protection of the individuals who take the Tylenol. In other words, the dosage does not have an error margin. And also it's arising from people who are suffering from the flu, who are suffering from dental pain or stomach pain, and they fast for a period of time, and the enzyme which takes away the toxic portion of the Tylenol is weakened or is not enough there, and it causes liver damage. So this is a major development. And so if you have a family member who's suffered from liver failure or even death, it's something to be aware of by way of litigation, that you may be able to get some help. And try to get local trial lawyers to help you. If you come to us or you come to another local trial lawyer, it's always good to have a local lawyer help you with mass tort litigation, say that is centered in another state, and it doesn't cost you any more, and you have somebody that can talk to and look out for you.
All right, thank you for the legal alert, Vic. We join now by Connie from Georgia. Connie had a tear in her knee. Connie, where do you think this occurred?
I'm not sure if it happened at home or at work, but I informed work that I had hurt my knee, and I'm a stocker at Walmart, and it just got worse and worse over time. It's been 2 years now. I didn't file a workers' comp claim. I went out on a leave of absence in August of last year, having to have surgery on my knee June 4th.
Okay.
All right.
Hang on, Connie.
Connie, you got a problem when you don't know how you injured your knee. It's going to be difficult to pursue a workers' compensation claim on the theory that you suffered the tear to your knee ligament at work. You may have a possible claim for aggravation of a pre-existing condition as a result of your return to work and the condition worsening over time. So I would consult a workers' compensation attorney as soon as possible to see if you still might have a claim, but there's a real problem when you can't show where the injury occurred, whether you were on the job or not on the job.
All right, real quick, Gary from Georgia got hurt 7 years ago. He's still working. Vic, the boss never filed a workers' comp claim. Is there something that you or another attorney can do to check into this with the employer?
Gary, did the employer ever pay for any medical bills or lost wage benefits?
Nobody's paid nothing except me and my insurance company.
Yeah. Gary, I think you probably waived any right to file a workers' compensation claim. As a general rule, you have 1 year or 2 years from the date of the last payment of income benefits or 1 year from the date of the last payment of medical benefits. And I think you probably waived any right to file the workers' compensation claim. But if you'll give us a call, we'll meet with you and see if we can help you out.
Well, great questions tonight. It affects all of us who are on the job. Mr. McCants, thanks so much for joining us. We appreciate it. We had both sides of the river covered.
Yeah.
Great questions, huh?
It's always nice when you have a good defense lawyer who can help the public as well, and we brought him on tonight because he is such a good guy.
And next week, Memorial Day weekend, we'll talk about getting hurt in Iraq. Have a great evening.